Hello, everybody. Welcome to the ISTAT Learning Lab. Today, we're going to take a look at airline bankruptcies and restructurings. We did that about a year ago with Dean Gerber, who is the president of ISTAT. But a year has passed and a lot of things have happened, so we thought it was time for a refresh and update. And to talk about that, we have three people from Norton Rose Fulbright, the law firm. And I just want to mention that with me today as a co-host to moderate the questions that you can write in the Q&A button at the bottom, I have Mamoon Kuzbari, who's the Chief Commercial Officer of Nordic Aviation Capital in London. Now, our guests from Norton Rose Fulbright are, first of all, Alisa Vasquez, who is a partner and head of the aviation detail at the firm in the US. And she works with lessors, airlines, and lenders. And she is also the vice chair of the legal advisory panel to the aviation working group and is the chair of the American Bar Association's Aircraft Finance Subcommittee. And we have Kenneth Gray, and he's a consultant based in London in the banking department of Norton Rose, and he has over 30 years of experience. And he specializes in advising clients on strategic issues such as implementation of Basel Accords and capital requirements, regulation, the ratification of the Cape Town Convention for the United Kingdom, and the consequences of Brexit. And Kenneth is member of the executive committee of the legal advisory panel to the Aviation Working Group and the chair of its UK National Contact Group. And then we have David Rosenzweig, who is a partner for Norton Rose in their financial restructuring and insolvency team in New York. And he has been involved in all the major Chapter 11 filings in the US over the last 25 years, 15 of them, to be precise, and he generally represents aviation lessors and lenders in cross-border aviation restructurings, but he's also now acting for Philippine Airlines in its restructuring and Chapter 11 case. And so just a reminder, you can post the questions during the presentations, and then Mamoon and I will go over those questions with our panel after their presentation. So with that, I want to hand over to Alisa.
Thank you, Niels. As Niels indicated, I think about a year ago, there was a presentation on restructurings, but they continue to occur. And the most common ones that are emerging that airlines and some lessors are using are Chapter 11 in the United States and UK schemes of arrangement. And I think trivia gave away some of what I'm going to say now, but you're all probably aware of it. Recent Chapter 11s in the United States include Avianca, LATAM, Aeromexico, and most recently, Philippine Airlines. In the UK, we have UK schemes of arrangement where Malaysia Airlines has utilized that. Virgin Atlantic utilized the UK restructuring plan. And it's been reported in the press recently that Garuda Airlines may also launch a UK scheme of arrangement. Now, other airlines have not used the UK or Chapter 11, but instead have utilized local proceedings in their jurisdiction and sometimes not in their jurisdiction. Thai Airways and NOC Airlines are in Thai bankruptcy proceedings. Virgin Australia utilized an Australian administration. AirAsia X did a Malaysian scheme. Norwegian Air did an Irish examinership and a Norway proceeding. H&A Group is in bankruptcy in China with the administrators appointed by the People's High Court of Hainan Province. And then on the lessor side, the only one that we have seen is a restructuring by Nordic Aviation Capital with an Irish scheme of arrangement. So with that backdrop of what is currently happening, I'm going to turn it over to my colleague, David.
Thanks, Alisa. I'm going to talk about some of those that are the ones that are in Chapter 11 in connection with restructurings that are going on right now. For example, the Latin American Airlines and PAL. So why don't we start with sort of the overview as to, and I think one of the reasons that we start here is it's one of the draws, I think, for Chapter 11, which is it's a management-led debtor in possession process. There's not an administrator or another bankruptcy official appointed. So it provides that benefit, I think, for companies as they're looking for a jurisdiction. Now, many other jurisdictions are copying and following Chapter 11, and they're getting there, and there's a lot of competition. But Chapter 11 still remains some would say gold standard for the restructurings. So it's a debtor-led process. It's a management-led process. The company stays in possession of its assets and its business, and can continue in the ordinary course. Now, typically, there is not a trustee appointed, as in some other jurisdictions. There can be in certain circumstances, but it's unusual. There has to be some misconduct by management that would cause the court to appoint a trustee, and it's not a common occurrence. Question we always get asked is how do these foreign non-US companies end up in Chapter 11? How can they utilize Chapter 11? And the bar for entry is very low for jurisdictional purposes. All that's needed is an asset or assets in the US or a place of business in the US, and the place of business does not have to be the principal place of business or in the international construct, the center of main interest at all. It just has to be any place of business in the US. And many airlines obviously have that, foreign airlines. Many foreign airlines will have significant assets in the US, equipment at airports and the like. But it should be noted that one of the types of assets that can land a company in Chapter 11 are bank accounts, including retainers held by law firms. So as you can see, there's not a high bar to joining a Chapter 11 here in the U.S. So I think that's one of the main high draws to Chapter 11 is low entry, and also management stays in place. Now, once we get into Chapter 11, why are the airlines, foreign airlines, some of them like the Latin American carriers and Philippine airline coming here? Well, a couple of things to start with in the toolbox. One is the automatic stay. Now, a lot of jurisdictions have stays and moratoria, but the automatic stay is well recognized across the world. And in fact, the US, at least from the US law perspective, believes, and the bankruptcy code provides, that the stay applies worldwide. It applies to any property of the debtor wherever it's located across the world. So in the global economy we're in now, international creditors have assets and businesses all over the globe, and so Chapter 11 is looked at as this is a positive, I think, for the company looking for restructuring, is the scope of the automatic stay, at least starting in the U.S. Bankruptcy code. The stay does prevent actions from being taken by creditors, including lessors or lenders. And in the aircraft context, at least in the U.S., we have, which we're going to talk about in a little bit, a special interest provision called Section 1110, and then we'll also discuss Cape Town as well with Ken later, which is very similar. But as a general matter, the stay applies to prevent creditor action. Executory contracts can't be terminated. Leases can't be unilaterally terminated at the start of the case. I think the second high-level draw is the ability to get DIP financing, which is a financing provided by lenders to the company after the bankruptcy for working capital purposes to fund the reorganization. Obviously, it's important for confidence in the airline and in any debtor that DIP financing, if needed, is obtained in order to keep the business running. it's become a pretty competitive business as far as the U.S. DIP loan market. Lenders are competing and incentivized to provide attractive terms, but they do get benefits from that, including super priority liens on the assets and super priority claims in the case. Now, one of the other I think points for lenders in making DIP loans is they get control to some extent of the case in a broad sense, as far as providing timelines and milestones to achieve the restructuring. And in some cases, you can utilize it for a loan to own type of transaction. So if we look at the Chapter 11s that have recently been filed, we see DIP loans being provided in some cases in part by the owners, or in other cases, including hedge funds and other companies. And the strategy may be for some of them to end up owning the airline as it comes out, or for purposes of the existing owner to acquire or reacquire the company. So, for example, we know in Latam that the DIP loan started out which included a debt to equity conversion feature. The judge had some problems with that. Ultimately, it was modified to satisfy the judge, but in essence, it's headed in that direction for some of these for Latam and some of the other airlines, Avianca, for example. And the one I'm involved in, Philippine Airlines, the DIP lender is the owner, and in the proposed restructuring would continue to be the majority owner of the company. So the DIP loan is a feature that can be used by existing stakeholders or third parties to essentially stay involved with the company. The next, I think, slide I think is really the meat and potatoes of why an airline would come to Chapter 11. And I think the power to reject leases or abandon collateral is one of the main tools in an airline Chapter 11. The debtor has the right to assume or reject executory contracts or unexpired leases. It can also similarly abandon mortgaged equipment or finance leases, for example, to secured creditors. And in that situation, the company can utilize this power and the threat of this rejection or abandonment to compel a negotiation around revised and market-driven terms for new or amended leases, or it can right-size the fleet to achieve a balance that it desires. In the context of the U.S. airline cases, we have seen it as well historically, the use of Chapter 11 to reject or renegotiate collective bargaining agreements with labor. Interestingly, we haven't seen that at least in Latin American airline cases in the last year and a half. We haven't seen that tool utilized, and that's not to say there haven't been renegotiations with unions, and there have been, but the tool itself hasn't been aggressively, at least rolled out in court for use by these airlines. And there's speculation as to why that may be, in the sense that you have non-U.S. companies whose labor contracts perhaps are situated in South America, other jurisdictions, and the question of getting those the orders up in the U.S. court on a rejection of a labor contract enforced in another jurisdiction may be something that is holding back the aggressive use of this feature, but it certainly is there and can be used in other contexts. Next on the I think agenda for the toolboxes is what Chapter 11 I think, really about. At a high level, the debtor can achieve an M&A transaction in Chapter 11, and many airlines, at least on the U.S. side, and historically have done that. If you go back to those U.S. airline cases, you can almost carry a trail from TWA in the late 90s through America West, US Air, all the way to American Airlines, all being consolidated in one form of a Chapter 11 M&A transaction or another. So we saw a lot of that in the US airline context. Not happening in the Latin American cases or the Philippine airline cases. Those are restructurings that are being done, not M&A transactions, as the US airlines, many of them did. So they're focused more on the next sort of tool in the box, which is how do you restructure the airline? And generally, you have a plan of reorganization in Chapter 11. The class thresholds are such that you need 2/3 in amount value in a class to vote to accept the plan. That's contra to some of the other jurisdictions which have higher thresholds. Schemes in the UK have 75% in value thresholds. Again, this probably is a selling point for Chapter 11. It's a little lower. In addition, you have the ability to non-consensually restructure debt. That was a difference that Chapter 11 had with other schemes and other proceedings across the globe. But in recent years, that has changed, and the UK and other jurisdictions have added cross-class cram down to their arsenal. And so we see that competition occurring. And that's also been done in Germany, the Netherlands, and other jurisdictions as well. So the ability to cram down draws debtors in general. Now in the US, we have to recognize, which we're going to get into, that we have Section 1110, and that prevents cram downs of aircraft debt and aircraft leases, but it only applies, as we'll get to later, to US airlines. And so that'll then spin into our discussion of the anti-cram-down provisions of Cape Town and how that works and how that interplays with a Chapter 11. But historically in the US, for the US airlines, you did not have an ability to cram down the aircraft financed debt at all. So it was mostly a consensual restructuring. And when Aeromexico, LATAM, and Avianca and PAL filed, there were some other features put in place that we'll get to on the next slide that essentially created 1110-like rights, I would say. So with that, I didn't talk about Section 1110, which I'm sure everyone on this call has familiarity with, but it essentially provides that at the start of the case, the automatic stay applies for the first 60 days. And the airline then must cure all the defaults on and before that 60th day and agree to perform the lease or financing of the aircraft going forward in order to maintain the stay and keep it in place. Now, this is what we call the 1110 election, and it doesn't finally resolve whether the airline is going to maintain the lease or the aircraft. It is simply an interim step to keep the stay in place while the restructuring can continue to be discussed and negotiated. Many times this 60-day period is extended, but it can only be extended with the agreement of the lessor or financier. It can't be unilaterally extended by the court, which is a strong feature of Section 1110. If that agreement is not made or it's not extended, then the creditor, the lessor, or the lender can immediately it's immediately entitled to the surrender and return of the equipment. and the airline is required to actually surrender and return the equipment. What that means, of course, is subject to differing interpretations and views, but usually there's a consensus reached, or at least a high-level agreement on between the lessors and the lenders and the airline as to what obligations should be met in connection with the return. But it's clear that you're not entitled to, as a lessor, the contractual return conditions. It has to be a reasonable return, but it's not fully what's required in the lease. And of course, we have that discussion quite often with clients on how that works and how that plays out. In addition to the initial, I guess, focus on the automatic stay, what Section 1110 does is it really prevents cram down of the aircraft financings and obviously the leases as well. So basically, it forces a negotiation between the parties in order to achieve a restructuring, because the options essentially are, if the airline doesn't reach agreement with the lender or lessor, then it's required to give the equipment back to the financier. Now, many times the financier is not all that interested in getting the equipment back, and so there's a negotiation, obviously a give and take between the parties. But it does force a discussion at least, and there can't be a move to unilaterally cram down the financing on the party. So that's, I think, one of the keys in Section 1110 to protect financiers. Now, what are the downsides to it? Perhaps, well, here's the big one, which we've seen in recent years, with the last year and a half, with the Latin American airlines and the filing of Philippine Airlines, is Section 1110 does not apply to those cases at all, because those airlines are not U.S. airlines. The statute requires a particular certificate pursuant to the United States Code, Title 49, and that essentially is a U.S. airline. So that Section 1110 doesn't apply to Avianca, doesn't apply to Aeromexico, LATAM, or Philippine Airlines. Now, again, I will say it again, we're going to talk about Cape Town a little bit, but Cape Town has a similar, obviously similar to Section 1110, and in the Latin American cases and Philippine Airlines as well, the parties have reached stipulations that were approved by the courts that, more or less provided similar rights to Section 1110 and Cape Town, in the sense of allowing for a right to terminate and have the equipment returned in certain circumstances with certain notice periods and the like. So we really haven't had a large scale disputes on whether Cape Town applies or how Section 1110 may or may not apply, but it's obviously pretty clear that Section 1110 wouldn't apply. So I'm just going to give sort of a high level talk or slide here about Cape Town, and then Ken's going to really get into the details on it. But Cape Town, which was enacted, is to mirror in a way Section 1110, and it does that, and in a way more, because it applies to any type of debtor. It applies to an airline, or it applies to a leasing company. So Section 1110 would not apply to a leasing company. So if a leasing company were to file Chapter 11, the only applicable provision would be the Cape Town Convention, if it had been adopted in the home jurisdiction of that leasing company. Cape Town has some stronger requirements as well on preservation of the equipment and perhaps return obligations. Now, the U.S. didn't adopt Alternative A. It did adopt Cape Town, but it didn't adopt Alternative A, I think on the theory that it had Section 1110. But at any rate, as we've mentioned, Section 1110 has some gaps in that it doesn't apply to a leasing company, and it doesn't apply to a non-U.S. airline. So that leads to the next level here, which is the application of Alternative A in a Chapter 11 case where the home country has adopted it. Now, we haven't seen that any disputes erupt on that score because, as I mentioned, in Avianca, LATAM, Aeromexico, and Philippine Airlines, the stipulations have created 1110-like rights, and some of the jurisdictions involved in Avianca, for example, Cape Town is relevant. In Aeromexico, it may not be because Mexico has adopted Alternative B, which is not as good as Alternative A, obviously, as we all know. So I think we haven't seen, bottom line is we haven't seen any arguments in the US about Cape Town yet. We may in the future. Obviously, there's strong arguments that it should apply in Chapter 11. That's not to say that an airline might not have contrary arguments. There's always, that's what makes litigation what it is. So, that's maybe to come in the future. So let me turn it over to Ken, who has deep knowledge about Alternative A and Cape Town in general.
Thank you, David. Thank you very much for that. So what I want to do is just to start off by looking at the way in which Cape Town interacts with Chapter 11 and other restructuring systems, and then move on a bit to to look at what's been happening in the market over the past year and how Cape Town has performed in those circumstances. And the problem to begin with is that Cape Town guarantees certain remedies to lessors and lenders, which on the face of it are contrary to the automatic stay, for example. So if we start with security agreements, Cape Town grants under Article 8 the right to the debtor following an event of default to take possession or control of the aircraft pursuant to the security agreement or the mortgage, to sell or to grant a lease of the aircraft, and if it wants, to apply for a court order authorizing it to do that. So if the debtor were to, if the creditor were to do that, exercising its rights under Cape Town, it would on the face of it be in breach of the automatic stay under Chapter 11. It's true that states that contract into Cape Town have the right to opt out of extrajudicial remedies, that is self-help. In other words, you have to go to court to enforce your rights. So certain countries, notably the PRC, the United Arab Emirates, Brazil, Spain, Argentina, and so on, require you to go to court. But that requirement to go to court to exercise your rights does not give the courts a discretion to stop you exercising the rights. It's simply a procedural requirement that you have to go through to make sure that debtors are properly protected. Move on to the next slide, David. And again, we have very similar remedies guaranteed to lessors under leases under Cape Town, which is following a default. You have the right to terminate the leasing agreement and to take possession or control of the aircraft, and similarly to apply for a court order authorizing the above. And states have the right to opt out of self-help rights. So again, on the face of it, that guaranteed remedy given to a lessor might be in conflict with an automatic stay granted by a Chapter 11 court. So the question that we have to ask ourselves is, how do we regulate this apparent conflict between the domestic law providing for a stay or for a moratorium and the Chapter 11 requirements? So we need to go to Article 30 of the Cape Town Convention, which says that in the convention, rules of procedure, which include things like stays and moratoria, relating to the enforcement of rights to property, which are under the control or supervision of the insolvency administrator, are protected. In other words, that applicable law relating to things like stays and moratoria are protected, notwithstanding the earlier provisions of Cape Town that I referred you to. So let's just have a quick look at the systems that are most commonly used. David has been through Chapter 11. I'm not going to add anything to that. As David mentioned, you have an automatic stay there. On the face of it, under Article 33, that automatic stay, if you like, is given priority over Cape Town. In the United Kingdom, we have two restructuring systems. We have schemes of arrangement and restructuring plans. I'm going to talk about them a bit later in a bit more detail. Schemes of arrangement, such as used by Malaysian Airlines, do not involve a moratorium and are available for any company. So we don't have to worry about moratoria under UK schemes. UK restructuring plans, which were brought in recently, they were brought into the UK last year by a statute called the Corporate Insolvency and Governance Act, or SIGA, does provide for a short moratorium. And again, Article 30, bracket 3, should protect that moratorium if a company applies for a restructuring plan. The biggest difference between a scheme of arrangement and a restructuring plan, which I'll highlight now because it becomes important later, is that for a company to apply for a restructuring plan approval, it must show that it is experiencing financial difficulties such that, absent the plan being approved, its viability as a going concern will be compromised. So restructuring plans are only available for companies in financial difficulty, whereas any company can apply for a scheme of arrangement. Okay. However, all that I've said about applicable law moratoria taking priority over Cape Town disappears to the extent that Alternative A applies. So the general provision under Article 33 that the applicable law on moratoria takes priority over the Cape Town remedies does not work to the extent that Alternative A applies in any particular circumstance. So we need to look a little bit at what we mean by Alternative A. Basically, the aircraft protocol allows states that contract into Cape Town to adopt one of three alternatives which relate to the commencement of insolvency proceedings by a debtor company, be it an airline or a trust company or a leasing company, by any debtor who has Cape Town aircraft objects on its books. So a state contracting into Cape Town can leave its insolvency laws unchanged. As David explained, that's what the USA has done because there was a belief that having Section 1110, they did not need Alternative A. That is a slightly flawed argument, as David was discussing, of course, because 1110 only applies to US certificated carriers, so it doesn't apply to foreign airlines coming for Chapter 11 proceedings in the US, or indeed to borrowers, leasing companies, trust companies, and so on, who are not certified airlines. The second possibility a contracting state has is to adopt Alternative A, and that is what the huge majority of contracting states have done. There's a third possibility, which is to select Alternative B. To my knowledge, only one state has done that, which is Mexico, and in the light of that, I'm not going to comment further on Alternative B. It's not particularly obvious why any country would think Alternative B was in its interest to select, but there we are. So let's look in a bit more detail at Alternative A. And there are two key provisions of Alternative A, which are set out in Article 11.2 and 11.10 of the Aircraft Protocol. Alternative A, often called the hard option. So 11.2, which is closely based on Section 11.10, says that upon the occurrence of an insolvency-related event, and we're going to come back to what that means in a moment or two, upon the occurrence of an insolvency-related event, the insolvency administrator or the debtor, as applicable, shall, subject to paragraph 7, we'll come back to that, shall give possession of the aircraft object to the creditor no later than the earlier of the end of the waiting period and the date on which the creditor would be entitled to possession of the aircraft if this article did not apply. So the waiting period is usually 30 or 60 days. What 11.2 says, it produces a limit, if you like, for how long any moratorium or stay can be effective under its applicable law. It cannot carry on beyond the end of the waiting period selected by the relevant contracting state. That is set in stone. It's not open for a court to say, for example, okay, we chose 30 days, but in fact, we don't think that's reasonable. We want to give you longer. The court should not, is bound by the decision made by the relevant contracting state. We had an issue there a couple of years ago with Ocean Air in Brazil. Some of you may well be aware of. The Brazilian court decided to extend the waiting period. That is quite clearly in breach of the convention, which does not permit any extension of that type. So the creditor has the right to have the aircraft returned to him at the latest at the end of the waiting period, subject to paragraph 7, which we look at now, which again is closely based on chapter 11. The insolvency administrator or the debtor may retain possession of the aircraft subject where by the time specified in paragraph 2, so the end of the waiting period, it has cured all defaults other than a default constituted by the opening of insolvency proceedings and has agreed to perform all future obligations under the agreement. As David mentioned, when you say all defaults, that includes cross defaults, as it does in chapter 11. I find this a bit difficult to understand, on the other hand, when you look at events of default, like the fact that the airline is technically insolvent, or that there has been a material adverse change in the condition of the airline. I don't think that Article 11.7 can be read as requiring the airline to reverse a material adverse change or to get itself out of technical insolvency. So I think we've got an issue there that at some point we may have to decide before the courts. I mean, some defaults simply cannot be cured. But clearly all payment defaults, performance defaults, or cross defaults of that nature would need to be cured as well. And it goes on to say that a second waiting period does not apply in respect of a default in the performance of such future obligations. So you can't say I will perform all my future obligations and default again the next day. 2 strikes and you're out. And the third part of Alternative A that matters is the Anti-Cram-Down Provision in 11.10, which is quite curious within Cape Town because Cape Town generally does not deal with financial obligations. It deals mostly with property rights. But in this particular provision of the protocol, we have a statement that no obligations of the debtor under the agreement may be modified without the consent of the creditor. So the debtor is, for example, the person granting a mortgage or the lessee. The creditor would be the lessor or the mortgagee, the beneficiary of the mortgage. No non-consensual cram down. The terms of the lease agreement, the terms of the loan agreement can't be modified. You can't change the interest rates, maturity dates, without the consent of the creditor. So basically what we're saying is that a dissenting creditor cannot be crammed down by a majority, either in Chapter 11 or in a UK scheme of arrangement or in a restructuring plan. And both the schemes of arrangement in the UK and the restructuring plans, on the face of it, were it not for Cape Town, would allow non-consensual cram downs in certain circumstances. So Cape Town goes out to prevent that. So all of that applies, and they give valuable rights to lessors and to creditors, but they're all conditional upon one thing, which I mentioned right at the beginning, which is that we have to have what is called an insolvency-related event. That is defined in the aircraft protocol, which in turn, it includes the commencement of insolvency proceedings, and insolvency proceedings are defined in the convention. And I'm not going to read out the definition there, you can read it yourselves, but there are 3 key elements here, is that they have to be collective proceedings, they have to be subject to control or supervision by a court, and they have to be for the purposes of reorganization or liquidation. Now, and this is where, particularly on this side of the pond, we get into controversy. Because there's been a lot of discussion over the past year as to whether schemes of arrangement, whether in the United Kingdom or in Ireland or in Malaysia, for example, constitute insolvency proceedings, and indeed whether restructuring plans under SIGA constitute insolvency proceedings. I'm talking about schemes of arrangement incidentally very much from an English point of view, but many of the countries that have a common law system based on the English law will also have their own domestic schemes available. You have them in Australia if you want them, you have them in Malaysia, in Ireland. So most common law countries will have some variation of the scheme. And as I say, there's been a lot of debate as to whether restructuring plans and schemes are or are not insolvency proceedings. And in the interest of fairness, I will tell you what the arguments are on both sides, although I have fairly strong views as to how the question should be answered. So the people who argue that these are not insolvency proceedings argue firstly they're not collective in the sense that some of the creditors of the debtor may not be party to the scheme. Secondly, that the proceedings are not subject to control or supervision by a court. So in England, if you apply for a restructuring plan or for a scheme of arrangement, the way it works is that you prepare your plan, you go to court, the court may give you consent for you to convene creditors meetings, it's called a convening hearing. And then if you get the requisite majority of creditors agreeing to the plan or the scheme, you then go to court again and you have a second hearing at which the court may sanction the scheme if it thinks it equitable in the circumstances to do so. So the argument here is that the involvement of the court is so limited that it doesn't amount to control or supervision of the assets and affairs of the debtor. And the third argument, which applies particularly to schemes of arrangement, is that they're not necessarily for the purposes of reorganization or liquidation. So it's perfectly true that you can have schemes of arrangement which are presented in a solvent scenario. You can have a corporate restructuring, or there've been schemes involving insurance companies that had contingent liabilities way out in the future. They wanted to compromise early, and they went to court, and they were allowed to do that. No hint of them being insolvent. It's simply a way of restructuring your business a bit. That is fine. That clearly would not be a proceeding for the purposes of reorganization or liquidation. The counter argument is that they are collective proceedings because there are enough creditors involved in the proceedings to make them collective, and that even for those creditors who are not involved, they will be expected to benefit from the proceeding going ahead anyway, even if their debts are not being restructured. That clearly the court having the yes or no veto right over the proposed scheme by refusing to sanction it if it wants to, gives it control over the affairs of the debtor. And finally, that if in fact the purpose of the scheme or the restructuring plan is to avoid liquidation, then that is a scheme being brought for the purposes of reorganization. The fact that the scheme is not automatically for the purposes of reorganization is neither here nor there. You need to look at the specific facts surrounding each particular proposal. So there's been a lot of argument about this. I'm just quickly running through the different ones we've had. So firstly, we had Nordic Aviation in Ireland last year. Again, Nordic asserted that this was not an insolvency proceeding and therefore Cape Town didn't apply, but they got sufficient creditor buy-in to the plan to get the plan approved without that argument having to be judged on by the court. Moving on to the UK, firstly, Virgin Atlantic applied for a restructuring plan. They also asserted in their pleadings that this was not an insolvency proceeding for Cape Town purposes, but again, they got unanimous creditor buy-in, so the court was not obliged to make a decision on that. Whilst we're on restructuring plans, there has been one other case which is important, which involves not an airline, but Gate Group, the catering company. A lot of you will be familiar with the airline catering company, which was also involved in litigation, or was applying for a restructuring plan in the UK. And the question of whether or not that was an insolvency proceeding was important, not for Cape Town reasons, but for reasons relating to another convention, the Lugano Convention. It doesn't really matter. The argument, is this an insolvency proceeding, is the same for Cape Town as it is for Lugano. And there the court held, looking particularly to the fact that to initiate the restructuring plan, Gate Group had to show they had financial difficulties, so that absent the plan, their continuance as a viable company would be compromised, the court there had no hesitation in saying that that was an insolvency proceeding, and the same, presumably the same logic should apply to an airline applying for a restructuring plan. Final thing, schemes of arrangement. Malaysian Airlines, as Alyssa mentioned, applying for a scheme in the UK. Again, same as before, they asserted these were not insolvency proceedings, but they got unanimous buy-in, so no decision from the courts. Well, there has been a decision from the courts is in Malaysia itself, where AirAsia X, applying for a scheme in Malaysia, asserted that the scheme they were proposing was not an insolvency proceeding, but that argument failed before the Malaysian High Court in a cogent and well-argued decision from the commissioner there, going through the authority in various common law countries, including England, concluded that that a scheme is an insolvency proceeding. So in England, we don't have a court decision yet as regards schemes of arrangement. We have one for restructuring plans. We have the Malaysian decision, which is persuasive. What I can say is that although we don't have a decision, the direction of travel is pretty obvious, going towards the conclusion that these are insolvency proceedings. And we're going to have a bit more help on that next year when the next official commentary for the Cape Town Convention is published. So if I can put it that way, this key, the direction in which the argument is going is pretty clear towards all of these being insolvency proceedings and therefore bringing in alternative A. So that was quite a long slide. I hope David hasn't fallen asleep. Thank you, David. Just one final thing before I hand over to you for any questions you may have, which relates to Article 30.4 of the Aircraft Protocol. I do apologize if you're not familiar with the protocol. I keep on bombarding you with article numbers and so on, but there we are. It's my life, so at least you can sympathize with me if you can bring yourself to do that. Article 30.4 is important, particularly in the US and the Chapter 11 cases being brought there. And what it says is that the courts of contracting states must apply Article 11 in conformity with the declaration made by the contracting state, which is the primary insolvency jurisdiction of the debtor. That is, you know, for an airline, that's going to be where the airline is regulated. For other entities, lessors, trusts, and so on, it's a bit more difficult. Let's just talk about airlines for now. The primary insolvency jurisdiction is almost certain to be where the aircraft is licensed, where the airline is licensed, excuse me. So for the Philippines, from the Philippines, Avianca, Colombia, Aeromexico, Mexico, LATAM, Chile. And basically, if you look at those, the Philippines and Chile are not contracting states to Cape Town, so Article 30.4 has no effect for the Chapter 11 court in the US. Mexico has declared for alternative B, so the Chapter 11 court would have to interpret that, and good luck. And Avianca in Colombia that has applied alternative A, therefore, you know, the US bankruptcy court, even though Avianca 1110 does not apply to Avianca, because it's not a US certificated airline, because of Article 30.4 and because Colombia has selected alternative A, then the US court should apply alternative A in that case. So there's a slight final thing I want to say about that, which goes back to Trans-Brazil, which I mentioned beforehand. The Trans-Brazil case before the US courts was actually a Chapter 15 case, not a Chapter 11 case. So it was about enforcing the judgment of a Brazilian court. And there, the court of first instance in the US, so the Brazilian court refused to apply Article 11 in conformity with the declarations that Brazil had made. It said that 30 days was too short a time to allow Trans-Brazil to restructure. At the Chapter 15 hearing, the argument was made to the US court that they needed to apply Article 11 in accordance with the declarations made by Brazil. At the time, the court of first instance refused to do that on the grounds that they were being used as an appellate court for the Brazilian High Court. I think that decision has been quite widely criticized and would have been appealed had Trans-Brazil v. Cochinare had they not settled their dispute with the lessors before the appeal became necessary. So I think that's all I have to say about Cape Town. I'm here to take answers, but I'll hand the screen back to Niels.
Thank you, Kenneth. So we have a few questions. Maybe Mamoon, you want to kick off?
Sure. First question is from Sundar. What is the advantage for a foreign carrier to file Chapter 11 up to Chapter 15 bankruptcy? Not sure, Elisa or David.
Yeah, I'll take that. The advantage is that Chapter 11 is the restructuring chapter for the company. Chapter 15 is an ancillary proceeding that is used to benefit and enforce orders and restructurings done in another jurisdiction. So for example, Air Berlin filed for an insolvency proceeding in Germany and then went to the US to have a Chapter 15 case to essentially impose the moratorium in the United States. So it's a very Chapter 15 is a very limited tool. It's not doesn't take over the restructuring. The restructuring continues in the other jurisdiction, which is the main restructuring jurisdiction, wherever that may be, wherever it was filed, as opposed to Chapter 11, which is the main restructuring proceeding.
Okay, thank you.
Similar one, maybe Niels, because I think that this also talks about foreign jurisdictions restructurings. Is there a benefit to the airline to declare Chapter 11 in the US or similar filing in another country before filing in its home country?
Yeah, I think that's really the question that a company or an airline confronts at the start of its restructuring, which is the best or most convenient jurisdiction to achieve the restructuring that's at issue. And they then decide whether that's the US in Chapter 11, or as some others have decided, it's a scheme of arrangement in the UK, or is it a local jurisdiction? So the benefit of Chapter 11 is that it's tried and true, it has a track record, but we know that many other jurisdictions are catching up and doing or enacting similar laws. And so it's become a more competitive marketplace, I think, for restructurings in recent years.
Maybe I could just jump in there with another point, David, which is that the great power of Chapter 11, of course, is that the automatic stay is worldwide. So, you apply for Chapter 11 protection, you get the automatic stay, your lessors are going to think very hard about repossessing the aircraft, either certainly not inside the USA or even outside the USA, with the risk of being found to be in contempt of the US courts. If you've applied for bankruptcy protection in, I don't know, in Indonesia for the sake of argument, and let's say that the Indonesian, I'm making this up as I go along, let's assume the Indonesian scheme provides for global automatic stay, lessors may be a bit less worried about breaching that and being found in contempt of an Indonesian court, for example. Yeah. So I think that, going for Chapter 11 protection effectively stops lessors defaulting. There will be a default on the leases, but they won't default the leases and repossess the aircraft, I think. So it has that strategic benefit.
Yeah, I totally agree. I mean, the international creditors will most likely respect the automatic stay in a Chapter 11. And given the global economy, they have assets in the US that potentially are at risk if they are held in contempt by the court. So it would only be an unusual situation where maybe a company had no connections to the US and they could roll the dice on that. But in this day and age, that doesn't happen often.
Okay. David, you mentioned that the debtor in possession financing would carry super seniority, but it wouldn't trump the rights of a mortgagee that holds an aircraft mortgage, right? Would it?
In the context of Cape Town or Section 11 applying, the DIP lender cannot trump the mortgage on an aircraft, assuming the mortgage itself has the usual provisions that a senior lien cannot be placed on the aircraft. So you would see in most of the Chapter 11 cases of the U.S. airlines, where clearly Section 11 and 10 applies, no question about it, that the DIP loans will not be granted on the aircraft that are already encumbered. The collateral will be other assets, including the mileage programs and other non-1110 type assets. So that's the 1110 construct. And Ken will tell you, and I'll tell you, and if Cape Town applies, it's the same result. So we've seen in some of the recent cases that they have not tried to trump the aircraft lenders in these cases just to avoid the fight. Now, perhaps it was only acute in Avianca, where clearly Cape Town would apply, but not others. But in any event, that's what they did.
Okay, and on the topic of DIP financing, you mentioned in the case of Philippine Airlines that the lender under the DIP financing was the owner of the airline. Was that
yes
correctly? That's kind of interesting, because that means that the owner of the airline is providing money to the restructuring airline that would then trump other creditors, and then I guess post emergence that loan could be converted to equity again, right? Isn't that a pretty smart way to preserve the money that is injected by the owner?
Yeah, I think it is, in the sense of trying to protect the company and the investment, because the absolute priority rule prevents the owner from, as we call it, it's the absolute priority rule. They cannot retain their equity interests unless the other creditors are paid in full. So the only way for an owner, and it's not just PAL, there's the other Latin American airlines, you have the owners involved in the DIP loan as well, is to fund additional money in to save the company, right the ship, and all that stuff, and then exchange it for equity on the way out.
Okay,
Yeah.
We have
I will just say that, just to say on that point, it's important to understand, though, that the DIP lender and the process has to be one that's marketed and transparent. I mean, the company can't just give sort of the loan to the insider and expect that it will sail through. I mean, you have to run a process and see what other competing lenders are out there and whether there's anything better. And because the company has a duty to achieve the best financing that it can.
Mamoon?
Yep, there's a couple of more questions coming in. Please keep them coming. If an airline goes into Chapter 11 and have unpaid maintenance reserves in the form of UPSIs, so I guess that in form of lessee to lessor, where does the lessor stand? Is the airline obliged to pay, or is the full UPSI up for debate? Is there any way to mitigate the lessor's risk around this?
Well, I think in this case, that's one of the probably items that might be negotiated or considered, depending upon the magnitude of the payment, as to whether the aircraft will be assumed or rejected or restructured. I think if on a high level basis, if the lease is assumed, then the maintenance has to be fully paid. If it's an 1110 or Cape Town case, then similarly it has to be paid at the end of the waiting period. Now, what may happen, though, is it gets deferred and is discussed and negotiated as part of the power of rejection that we talked about, as to what the amounts will be, both going forward and to cure ultimately in an exit. Because in whether it's Cape Town or Section 1110, there is a consensual restructuring that's at play, and the airline still has the right to reject, which means you return the aircraft, and the maintenance reserves would not be paid then in that case.
Okay. Then there's a question from Gerard Melling. I don't quite understand the question, but I'm sure Ken can sort this out for me. is there an issue of non-English insolvency proceedings affecting lease and security documents governed by English law?
I think the question there is that supposing we have a Chapter 11 proceeding and a modification to the leasing or the finance documents is required by the US court, would that be recognized by the English court? And I think we need to look at I don't have like a clean, straightforward answer to that. You need to look at where the judgment is coming from and whether they would be recognized in England or not. So in fact, the Gate Group case I was telling you about earlier involving the catering company also involved whether judgments in this case in England would be recognized in Switzerland, as it happens, with both parties to the Lugano Convention. So you need to look at the bilateral recognition agreements between the two countries in question. If that is clear. David,
Ken, this is the so-called rule of Gibbs, right? Which says it's an old English case that provides that only an English court can modify or restructure English law documents, and so I think it was recently upheld as still valid under English law, and so it is a feature that's discussed much, but I haven't seen it fought about here in the U.S. In any of the Chapter 11s, and certainly Chapter 11 purports to modify all sorts of things, including English law documents and others. So,
yeah, so I think that's right, David. So we start off with that common law rule. Then there's certain countries with whom we have bilateral arrangements. For example, not anymore, but we used to have it with other member states of the EU, with Switzerland and other countries in which we would recognize their insolvency proceedings. The problem with the US, of course, is that even if they're not recognized by the English courts, the creditors are going to recognize it anyway for fear of being held in contempt, as we discussed earlier. So just as a practical matter, there will be a Chapter 11 proceeding is likely to be recognized in the UK de facto by the creditors.
Okay, Amun.
Yeah, one more from Sundar Raghavan. What does the right for a foreign carrier to file for Chapter 11? Do they have to have any percentage of the overall asset in the US? I guess I know the answer, but go ahead, David.
The answer is no. It can be very small, and there's no percentage test. As I mentioned, it can be bank accounts. It can be even the attorney retainer for the company, because that retainer is an asset of the company, subject to the charging lien of the lawyer. So we've seen many cases in the shipping industry where these retainers and other bank accounts satisfy the test, and they're not it's not that hard to meet.
Okay. Another question. You mentioned about Chapter 1110, and we've talked mainly about airlines filing for Chapter 11. But when this may be totally hypothetical, but what would the circumstances be if a lessor had to seek protection under bankruptcy? Could they go and do it with Chapter 11 in the US? And what would happen to 1110? I guess that doesn't apply, right?
Yeah, Section 1110 clearly does not apply to a leasing company. It only applies to an airline with a US certificated airline. So you flip right into Cape Town if the home jurisdiction of the leasing company, if it's a non-US leasing company, if it has adopted Alternative A, and Cape Town and Alternative A in particular. So I think that's ripe for the next level of discussion here if there's a US filing for a foreign leasing company.
So that could conceivably happen. I mean, that is okay.
Yeah, oh, definitely. A foreign leasing company could file in the US, and under the test for jurisdiction and assets, I'm sure they'd be easily, have assets here in the US, bank accounts, perhaps even equipment too,
Yeah, and the big advantage then of Chapter 11 in the US, rather than filing for bankruptcy in your home country, is that in all likelihood, this would offer the company to have a management-led restructuring process rather than led by a court-appointed person, right?
I think that's a draw for sure. Has been for many years, and other jurisdictions are catching up and have included management-led and debtor in possession proceedings in recent years. But since Chapter 11 has been around so long and it's got a track record, people feel comfortable, continuing to utilize it. And I think that's, one of the reasons the Latin American airlines and Philippine airlines have filed. And, in addition, there is something to be said for how the creditors view matters. And a lot of the international creditors do feel comfortable with Chapter 11, perhaps. And so they're not opposed to it, so to speak. Where the foreign airline has come in, you haven't seen any arguments, I think, in court against the recent filings. I will go back a long time to the first Avianca case, which was in 2003 or 4. And in that case, some of the lessors sought to dismiss the Chapter 11 case on the theory it should be, have been filed in Colombia. And the court did not agree, but I think that lessors haven't made any similar type arguments recently.
I think if I can just talk from the English perspective, which of course also, schemes of arrangement and restructuring plans are also debtor-led, management-led processes. There was a fear at some point that people were going to try to use the insolvency proceedings argument I was talking about beforehand. So, for example, there was a fear that Malaysian might try to apply for a scheme in the UK, say this is not an insolvency proceeding and therefore alternative A does not apply, when had they done the similar process in Malaysia, alternative A would have applied. So there was a fear there may be some type of forum shopping going on to try and evade the mandatory rules. I think it's fairly clear now that simply would not work. If assuming these were insolvency proceedings, I'm pretty sure I didn't mention there's a huge legal opinion for those who are interested on the AWG website from Professors Gunniford and McHale as to why these are insolvency proceedings. Assuming that, I just can't believe that a court would somehow be complicit to a sort of blatant piece of forum shopping of that nature.
That's reassuring. One thing linked to, but not directly, is the EETC. I'm sure you've seen the LATAM rejection day one of their 20 plus aircraft on a EETC, and the subsequent sale of the assets using a process of was a stalking horse bidder and other certain terms that not all the stores were viewing favorably. And any comments you would have on this case, and whether you see the EETC being changed, the future EETC having certain change clauses regarding the to avoid this case or not?
Well, I think we're actually involved in LATAM also as representing them as Air Aviation Council. Personally, I wasn't involved in this, so I don't have a lot of information on that. Although I know that it was a sort of an industry hot point for sure, but I don't have the details on it.
I think the AWG have published a statement of principle dealing with intercreditor negotiations to reflect the problems there were with the EETC, which again is up on their website if you want to look at that. Those clearly are recommendations, and I think my take on that is that this is simply a question of how you negotiate your contracts, and that people, duly note holders having been sung, will be thinking harder about what they need to be looking at in those contracts in the future. Yeah. I just limit myself to that sort of other airy-fairy comment, if you don't mind.
Was that paper that the AWG published, was that prompted by the LATAM auction, or was it?
Yes.
I believe so.
Yes.
All right. Yeah. Okay, cool. Well, I don't think there are any more questions. I look at you guys as the surgeons of this patient here, which is our airline industry. And so I hear all the best in your various treatments going forward. And then I thank everybody for listening in, and we see you back. I think there is another Learning Lab next week. Just check the ISTAT.org website. Thank you, Alisa. Thank you, Ken. Thank you, David, so much. And thank you, Mahmood. All the best to everybody.
Thank you.
Thanks. Bye.
Yeah.
Thank you. Bye.